Well, hello everyone. How are you doing? I don't know how long the will stay on today. I'm going to be doing a show about Lancey Clancy, family annihilator, mentally ill, or both. That's what we're going to talk about today. There's been a lot of family annihilators in the history of the United States. This is not new. It's out there. But I want to talk about her for just a few minutes. So I'm going to give people a couple of minutes to come on in. If you're out there, come on in. I look forward to seeing everybody today. I've just been a little bit, tiny bit ill, but we will go as long as we can. So let me get a little music on while I pick up my other couple of things I need to do my show with, and we'll get going. Thank you so much, and always appreciate everybody who stops by to visit with us. It's always fun. Here we go.
Pulling up clean in a GL whip, Kenny Red Flash with a turbo kick. Lil Laredo, yeah, the name's on fire. Burning up the road, taking dreams higher. 0 to 100, no time to stall. Every frame, every post, yeah, he does it all. From the streets to the screen, he's got that glow. Welcome to the ride, it's Lil Laredo. Red line dreams, we don't slow down. Engine roar when we hit your town. Makes it start so sharp like a midnight show. Oh gas, no brakes, little no. Gas, no brakes, little no. Drift through life with a fearless tone. Every move custom, every vibe is on. Not just a car, it's a way of life. Precision, passion, cutting like a knife.
All right. Now, before we do this, let's go ahead and read our let me see if it's still there or not. I put it in my notes, but I'm not sure if it's there or not. Let me go see. Hang on. Okay. Oops. All right. Let's go ahead and read our declaration about fair use. So just a second. I'm going to go ahead and take care of that right now while we're sitting here. Now here we go. Oh, not that one. Here's our fair use disclaimer. This video contains material used for the purpose of commentary, criticism, news, reporting, teaching, scholarship, and research under Section 107 of the U.S. Copyright Act. All video clips, images, documents, and audio referenced in this content are used in transformative manner to provide legal analysis, commentary, and educational discussion regarding true crime cases, court proceedings, and criminal appeals. The content presented is not intended to replace the original sources, but to analyze and discuss the events and legal issues involved. This channel does not claim ownership of third-party materials that may appear in this video. All rights remain with their respective copyright holders. The use of these materials is believed to constitute fair use because the content is transformative, adds commentary and analysis, and is presented for educational and informative purposes only. There you go. That is our fair use disclosure. Now, what we're going to talk about today is family annihilation. Is family annihilation mental illness? Is it, could it be mental illness and something else? What causes a person to become a family annihilator? You don't just wake up one day and say, I'm going to just take the whole family out today, because that's just what I feel like doing. I just don't believe that that's the way it works. I believe it has something to do with an ongoing, increasing mental illness. I really do think it is part of an illness. I mean, they're not just a psychopath. They're not just a sociopath. There's a lot of different factors that come into play before somebody's actually considered to be a family annihilator. I mean, it's not just because they took one person out, because they've taken their whole family out. all their children out at once. That kind of thing makes you a family annihilator. I mean, look at Chris Watts. Look at what made him do it. But there's also a discussion about family annihilation and gender. Is it more likely that a family annihilator is going to be female or male? Or is it both? Or is it equal percentages for both? That's the question, right? So, family annihilators, those who commit familicide, which is what it actually is, are they're predominantly male. So, Lindsay Clancy is an outlier per se. Okay. With cases overwhelmingly driven by a loss of control, such as financial crisis or separation. Male perpetrators often exhibit a history of domestic violence, whereas female perpetrators, who are rare, are more likely to be driven by mental illness, severe abuse, or to premeditate the act to include very young victims. Okay, so the key gender differences in familicide. A male perpetrator, their motivations are driven by perceived loss of control, including financial collapse, debt, or impending separations or divorces. They have behavioral patterns. They don't just wake up like this one day. There's been things that led up to this. There's been behaviors that led up to this that people did not notice the red flags. Okay, frequently demonstrated a history of domestic violence, intimate partner abuse, or passive control. Their methods they're often impulsive or reactive to a crisis. Whereas your female perpetrators, their motivations are more frequently linked to severe mental illness. Okay, and this is Lindsay Clancy. Lindsay Clancy's going with postpartum psychosis, depression, or as a response to being abused themselves. Their behavioral patterns are more likely to premeditate the murders. The victims' ages are likely to kill children under the age of 1. While men are the vast majority of perpetrators, both genders often kill the entire family unit, including the spouses and the children. So that is the discussion that we're going to have today about familicide, family annihilation, and is it mental illness? Is it something else? Is it both? What are the 4 types? There's 4 types of what are the 4 archetypes of family annihilators? Let's talk about that for a minute. There is a study of the British male family annihilators from 1980 to 2012. It's Yardley et al. This is from 2014. It identified 59 cases through a search of media databases and proposed taxonomy comprising 4 types of family annihilators: the self-righteous, the disappointed, the anomic, and the paranoid. Okay? The typology of the familial perpetrators in Australia. Now let's look at this one for just a moment. Because it happens in all countries. You're going to have family annihilation. It's just going to happen, right? So we're going to talk about this for a second. In abstract, the murder of family members is one of the most difficult crimes to understand. The study uses Shy's action systems framework combined with multivariate type data analysis to test the hypothesis and the different forms of familicide, which will reflect the 4 states an action system can take. Namely, there's the hang on, guys. There's the integrative. Sorry, a little bit ill today. Y'all just got to bear with me. My throat's a little. Anyway, there's the integrative, the expressive, the conservative, and the adaptive. A multidimensional scaling analysis, or the MDS, was performed on 54 crime scene variables, describing 104 cases of intrafamilial homicide. Okay? The analysis revealed 4 distinct modes of functioning, which provide tentative support for Shy's action system. Each one of the 4 modes has distinct associations with perpetrator characteristics. The expressive and integrative modes were associated with cluster B personality traits. Now, we've seen cluster B personality traits in many different people, right? And so it's the personality B cluster traits and the criminal and substance use histories. The adaptive mode was associated with trauma histories, mood disorders, and personality disorder traits. The conservative theme was associated with trauma histories and psychotic disorders. Implications of findings for risk assessment and intervention are discussed. So let's go ahead and we're going to read this study real quick. And here are the key words to think about when you listen to this study. action systems, familicide, family law, filicide, homicide, and multidimensional scaling. Now here's our introduction into this study. I think it's an interesting study, and I wanted to talk about this today to help us understand exactly what happened or what went wrong with our latest that we know of, which is Lindsay Clancy. I'm sure that she's not the latest. There's another lady in Texas as well that took her children out like that. I'm trying to remember her name right quick. Anyway, we'll just keep going over here because I'm talking about her too, and I'm going to keep up with her case. Romulus. Her name is Romulus. The lady's last name is Romulus over here in Texas. Then I'm going to track that case as well. So here's our introduction to this study. Familicide events are often described as inexplainable and coming out of the blue. Developing a deeper understanding of the factors leading up to these events might permit the identification of unique risk markers. So the red flags that are often missed. Let's pull up a picture of Lindsay Clancy while we discuss her and her case. So just give me a moment. Here we go. Come on, let's go. Hope everybody's having a wonderful day today. No, not her. No, I was watching the Supreme Court today as well. Lots of things going on over there. They did a traveling court today, which is interesting. We will get back on that because I enjoy watching that as well. Okay, now this is going to be from Court TV. Hang on. This is from Court TV, and this is actually from 3 days ago. So we're going to watch a little bit of this, and then we'll get back to our study on Lindsay Clancy. She decides that she wants a hearing, okay? She wants to go to trial. So let me share my screen. Here we go. Escape. All right, let's go ahead and share our screen so that you can all see what I'm seeing. No, not that. Come on. Oh. It's supposed to rain today, but it really did not ever start raining. So here's our screen that we're going to share. And this is from Court TV, and it's from 3 days ago. So we will be giving full credit to Court TV. Here we go. And we'll let this play for just a minute, and then we'll get back to our study.
Your Honor, good afternoon, all. This is 2383 CR 198, the case of Commonwealth versus Lindsay Marie Clancy. This case is called for motion hearing. Counsel for the record, begin with the Commonwealth.
Good afternoon, Your Honor. Jennifer Sprague for the Commonwealth.
Toonie Sprague, good afternoon.
And Shannon Buckingham, also for the Commonwealth.
Buckingham, good afternoon.
Good afternoon, Your Honor. Kevin Reddington on behalf of Lindsay Clancy, who I believe is with us on Zoom. Yep, she is.
Toonie Reddington, Ms. Clancy, good afternoon.
Good afternoon.
All right, so this was put over today in regards to a couple of motions that had been filed by the defendant. Commonwealth filed their opposition, which I had an opportunity to go over. So why don't we deal with, I know that there was a motion regarding juror information.
All right.
My thought on that was to maybe defer on that, only because we're going to have to figure out, so early in the situation now, we're going to have to.
Okay. In order to stay with our fair use disclosure, I had to put my little filter over this. This belongs to Court TV. Full credit to Court TV. Thank you for sharing with us. I put my little stars over it to meet some fair use standards that it's expected out of us here on YouTube. We want to share, but we want to share fairly. So here we go.
Find out how many jurors are coming in, who's coming in. I have no problems allowing that motion, but just to have a better idea of the specifics. That was kind of just my thought. But well, I guess Mr. Reddington, your motion, I know what your thoughts are in regards to that.
I know when to defer, and I'll defer to you in your judgment in that regard, because obviously you're not opposed to our getting access to the jury information well in advance of trial for us to do our investigation, so that's fine.
All right. Commonwealth?
I have no objection to deferring either. I just would point out that the Commonwealth filed its own motion because we're looking for slightly different information, and we're objecting to a portion of the information defense is requesting. So I do think at some point we just need to hash that out.
All right, we can do that right now.
Okay. The only thing we're objecting to is the contact information of the jurors. I don't think we're entitled to that, and I don't think we should have that prior to trial. And that, I believe that was in the defense counsel's motion. In our motion, we're just looking for the dates of birth, the addresses, and the names.
All right, Mr. Reddington?
I agree, Your Honor, that my understanding of the status of the law as it relates to contact with jurors is that once we actually start a trial, we're not supposed to, for obvious reasons, which is fine. And then you have the Fiddler case, it talks about post-verdict. I tend to agree as far as the request of contact info. I would not be thinking in any fashion of having a private investigator go out and talk to potential jurors or anything. I just need to know who they are and their addresses. That's all.
All right. So my inclination would be not to allow the contact information, but the rest of the information. So my thought would be to put this off till a little bit farther down the road, so we know kind of when we can get that information, and then I can kind of tailor the order along with that after we talk to the jury commissioner and figure out the jurors that are coming in. But like I said, I'm inclined to give that other information to both parties in advance of the trial impanelment. So, all right. The other motion that we had was regarding the bifurcated trial. So why don't, Mr. Reddington, I'll hear you on that, and then I'll hear from the Commonwealth.
Thank you. Your Honor, first of all, as you know from looking at my motion and the memoranda, also from looking at the government's opposition, there is a bit of a dearth of law on this issue, quite frankly. I think that's not just statewide, it's pretty much nationwide. But one of the things that's really...
You know, again, for fair use, we have to stop every once in a while. But, you know, when he's talking about this bifurcated, that means he's trying to split this trial. It's not only that she has the psychosis that she's trying to go with, but then we're going to have the aggravating, the mitigating circumstances as far as whenever they do the actual do the part of the trial where they actually decide what is her punishment going to be. So they're trying to, I mean, this is the split of this. It's a bifurcated trial. So just to kind of give you an update on what that means. Okay, we'll keep going. Thank you. Let's keep watching. Thank you, guys. Thank you so much for coming in. I always appreciate
compelling to me in reviewing the language from the various opinions is that there's no doubt that this is commended to the sound exercise of discretion by the trial judge. So you've got two issues in play here. Number one, do you, as the trial judge, feel that, in fact, it's a legitimate concern that we've raised and it's a legitimate procedural proposition that we present to the court as far as the logistical considerations involved in trying the case in a bifurcated sense, and then also the constitutional implications, if any there are? And I suggest to the court that, first of all, the government has quoted the many times quoted Siegfried case, 88 case, dealing with a guy that burnt down a dwelling house, and they're talking about basically the introduction of evidence of prior testimony of a witness in a probable cause hearing, and the witness was then unavailable. But in dicta, they do talk about the fact that it does not appear as though there is a constitutional let's say, obligation, if you will, on the part of the court to provide a defendant with the bifurcated trial. But they don't really get into a consideration of that. They don't really get into a discussion of it. They talk about cases that had been cited in the past, Commonwealth versus Bumpus, MacArthur versus California, and these go back. They go way back. Commonwealth versus Stewart at 359 Mass is one that where the court notes that the one issue that's of a concern is that you have the issue of criminal conduct, is their language, the way they use it, criminal conduct and criminal responsibility. So we have two separate concepts that would have to be presented during the course of the trial to...
Let's talk about that for just a second. criminal conduct, number one, and criminal responsibility, number two, being seen as two separate issues. Well, think about this for a second. Just because you know right from wrong and you do something, does that mean that you're not responsible? No, it does not. So I think the reason why he's bringing this up is, again, he's wanting to actually find sympathy for her because they are going with that she had a psychosis of some sort. However, she was also diagnosed by a doctor that she did not have postpartum depression. So that's going to be an uphill battle for these guys in this trial. So anyway, let's just keep watching.
Jury. One, whether or not the defendant is in fact determined by a fact finder to be guilty of the offense as indicted or any lesser degree thereof, and whether or not that person has the mental, and again using the SJC language, mental responsibility. Now, I think that the cases are fairly old. That's 78, thereabouts. So that's why they're using language such as mental responsibility. As we all know now, we're talking in terms of the defendant having the ability to know, and the government's burden of proof. The government's burden of proof, beyond a reasonable doubt, not only as to whether the person has committed the offense, but whether or not the defendant at the time of the commission of the offense was suffering from, or was not, I should say, on the government's obligation to prove to a jury, defendant was not suffering from a mental disease or defect, such as preventing the defendant from either, it's in the disjunctive, either understanding or appreciating the criminality of his or her conduct, or...
Okay, let's stop for a second. Now, if y'all will remember, this was just the other day that we saw this case where the Amish lady was found not guilty by reason of insanity. And she had given her 4-year-old child to the Lord. Remember that case? If you don't remember it, let's go ahead and show it for just a second. We'll bring this one up over here and share that one too. Because I found it interesting when I listened to the judge just give her sentence or describe or give her, she chose to go with a bench trial, which in a case like this, I truly believe the bench trial is the way to go. Okay, because you don't have 12 people judging you. You have a judge with all the knowledge of all the law right in front of him who's better able to make that decision. So if I was her, if I was not Corey Richards, I'm sorry. If I was Lindsay Clancy, I would pick a bench trial myself. So let's look at the case over here of this Amish woman, the Amish woman who drowned her child. Can't remember her last name for the life of me right this minute. Okay. This one right here. Her name is, this is going to be from Law and Crime right here. And this is just what happened with the other day with her case. So let me start back at the beginning. Hang on a minute. Let me pick this one. Let me put it right here. And it was a shocking bird is absolutely correct. So let's go over here and share my screen with this other one instead. Stop sharing this screen. We'll come back to that one. We'll share the screen. I want y'all to listen how this was handled because she chose the bench trial instead. Okay, it's going to be full credit to Law and Crime. Thank you so much for sharing. And here we go.
In the case of the Amish mom accused of killing her 4-year-old son.
I gave him to God.
You gave him to God?
Yes.
What do you mean by that?
I threw him in the lake and I gave him to God. And people are going to tell me I am crazy, but he is real. And he loves you. He really does love you.
This is what Ruth Miller told investigators after law enforcement say she killed her son and then tried to harm her older children in a vacation that turned violent in Ohio. Today, Miller's fate was put in the hands of a judge who made a bombshell decision. We're on the case presented by Law and Crime. Video of Miller in court today for her trial. And this was a very unique.
Now, I want y'all to stop and think about, look how she looks, and then remember how Lindsay Clancy looked. Not that looks have anything to do with it. But when you listen to this lady talk to these officers, clearly stating exactly what she did, just very matter of fact, she gave them to the Lord. Her husband was eaten by a fish that morning, and it's all real, right? It's very, very different than when you listen to Lindsay Clancy. So here, we'll just listen to this for a minute and let you hear this.
Situation. The entire trial lasted roughly an...
Let me say this, though, before I finish playing this. She is a family annihilator as well. She was trying to take the entire family out when this took place. The two guys standing over there are her 18-year-old twin boys who watched all of this take place that day, and you can tell by watching them, they are stunned at what they're seeing. Here we go.
Hour. That's it. Miller waived her right to be tried by a jury of her peers and instead opted for a bench trial with the judge having the final say. Now, before we get into what happened in court today and what the verdict was for Miller, I need to bring you back to what happened on that terrible day last year. Not only did Miller's 4-year-old son die, but her husband also died, but not at the hands of his wife. Miller is Amish. She and her family were on vacation at a place called Atwood Lake. It's about an hour and a half south of Cleveland. On the morning of August 23rd, the Miller family was doing some sort of religious exercise while they were on vacation. Law enforcement say they got a 911 call about a woman in a golf cart with 4 people on board driving into the lake. This is a picture from the local sheriff's office of the golf cart in the water. Now, when deputies responded for what they thought might be a water rescue, they ended up confronting Miller. And as you watch this body cam video, you can see that they start to realize that this was not an alleged accident.
I gave him to God.
You gave him to God?
Yes.
What do you mean by that?
I threw him in the lake, and I gave him to God. And people are going to tell me I'm crazy, but he is real, and he loves you. He really does love you. He loves you.
Let me just say this, because I want you to realize Lori Vallow is also a family annihilator. I know, and you go, what? Yes, Lori Vallow is a family annihilator herself. But when you listen to Miss Miller speak, and you think about how Lori spoke, and then how Lindsay Clancy spoke, you can clearly see that Miss Miller over here really is having a mental breakdown of some sort. Here we go.
And I doubted him. I doubted him so many times. But I am to tell you, he is coming soon. He is coming very soon. Prepare your hearts. The end is close. And I'm for sure supposed to tell you that he does love you. Okay?
Ma'am, can you explain to me what happened? Who'd you throw in the water?
I gave my son to God.
Your son?
Yes.
Where's your husband?
He went for a walk this morning.
And you haven't seen him since?
He didn't ever come back. And we went to the boat and his clothes were there. And God told me he's in the lake and a fish swallowed him. And you're actually supposed to go look for him in the bottom of the lake. And you will find the fish and you will find my husband. And then you will believe. But ye of your little faith that did not believe before seeing.
Okay.
So send people down to the bottom of the lake looking for a fish.
How old's your son that's in the lake?
4. He's sweet. I love him. I do.
Okay. 7940 Central. Right with the mother, she is advising that she threw her 4-year-old son in the lake to give him to God.
Deputies say that Miller's twin 18-year-olds are with her, but she keeps talking about her son and that her son is 4 years old. And as deputies continue to have this conversation, there's a chilling revelation that takes place because they realize that there is no 4-year-old in sight. And that is when law enforcement realized that they are dealing with a much dire situation than they first thought.
They are there.
See, at first, when they first started talking to her, they did not believe that she actually threw her child in the lake over there. They did not believe that she had put the child in the lake or threw him in the lake. They thought that you were just talking to somebody who was having a mental breakdown of some sort. But what's odd for me is the adult or the 18-year-old twin standing behind there watching all this going on, and they're not saying a word to the police officer about please believe her or my little brother's out there in the middle of the lake. It's very odd the way they acted while all of this is going on. I know they're in shock, bless their hearts. This deputy here is in shock too.
then Payne came back to me. My husband and I both got him. And Payne came back to me.
I need to know where your husband's at.
He's at the bottom of the lake in a fish.
He's in a fish.
Yes.
There's no fish large enough on an outlet to swallow your husband.
He's at the bottom of the lake in a fish.
Okay.
I thought your husband went to the front for a walk.
Yeah, and then we came to the boat, and his clothes were laying in the boat.
Okay.
Tan
Yeah.
pants and cream shirt and flip flops.
Do you have a cell phone?
It's in the camper.
It's in the camper. Where's your camper at?
I think it's.
Area 3?
I think so. Yeah, it's like a tannish camper.
It's a tannish camper. You don't know what lot number it is?
No.
Well, we really need to verify your husband's still with us.
Oh, okay.
Okay.
Well, he's actually just go out in the bottom of the lake.
Well, I can't go in the bottom of the lake. So
Do you
we
have
need,
scuba divers?
we're going to have to call divers in and go to the
Okay,
bottom of the lake.
please do.
And you're saying
Get the best ones there are, because this
So-
is a miracle from God. And you will see. You will see.
your 4-year-old son's down there too?
He's with God.
Where's his body at?
I don't
Where
know.
did you throw him in the water at?
Off of the dock at the causeway.
Where the bike was today?
Where the boat was?
Yeah, where the boat is. I know.
No,
When there's supposed to be one.
I think there was one.
Does anybody have a glass of water?
We can get you water.
I mean, listen to her. She's not even like frantic. She's just, as a matter of fact, telling the story. She doesn't seem upset. This is a miracle. This is a miracle. My God. But when everybody, I mean, that's what makes me, I truly believe that she's in some kind of weird psychosis there, because she's not showing any emotion at all. None. Flat.
Thank you.
Now, another person that is important to talk about in this story, even though Miller was not facing criminal charges in relation to what happened to him, was her own husband. He was missing. He was nowhere in sight. We'll talk about him a little bit more in just a moment. Now,
hang
the
on.
body camera video of the day that...
I'm going to show you something here. We're going to move on past for just a second.
That saw her driving will tell you she was driving very dangerously. She flipped the cart at one time. She was seen on 2 wheels another time. Of course, she was praying by the kayak. And she left. The children saw her leave with the 4-year-old. And then a while later, she came back. She states that she went to the dock and that she threw the 4-year-old in because that's what she needed to do as an offering to God.
No matter what you think of the verdict in this case and the dynamics that were at play, it is just terrifying to think of what that young boy, just 4 years old, what he went through at the hands of his own mom. Law enforcement say that Miller drowned the boy as a religious offering. Then, hours later, she ended up driving her older kids, those 2 18-year-olds, in the golf cart down to the water in what was another religious offering, which is why we saw that image of the golf cart in the water, and that prompted the 911 call.
7940 Central.
I mean, so we've seen kind of how this happened, but I want to take you down to where the judge actually, when she has her bench trial that lasts exactly 1 hour, and it's a shocking verdict, but I can kind of understand why. But so now, I mean, we have seen, we'll talk about that in a minute. Let's just watch the rest of this really fast about what happened in court, because this is where it gets odd and shocking, but it's understandable. So they're there. I mean, there's the divers looking for the babies right there, and the husband. Okay, and so they find the husband. Here we go.
15-year-old daughter on board. Miller also faced 3 counts of domestic violence for allegedly driving the golf cart with the 15-year-old, as well as her 2 18-year-olds on board. Now, Miller's defense attorney never disputed what Miller was accused of doing at the lake, as far as driving the golf cart with the people on board and, sadly, throwing her 4-year-old into the water. But her attorney was very public, and even after her first court appearance, told the media that this really wasn't a case of a whodunit. Those were the words that he used. But what he did dispute was what was going on in Miller's mind at the time that she did all of this. He says that she was insane at the time that she killed her son and then tried to harm her other children. Miller pleaded not guilty to those 7 counts by reason of insanity. And that brings us to today and a kind of court proceeding that you don't often see. No jury, no days of court for a trial, just 1 judge and 1 hour to decide the fate of this mom accused of the murder of her young son. Now, the judge said, based on the evidence, Miller killed her son and then tried to harm her other children.
I make the following findings, including that on or about August the 23rd, 2025, in Tuscarawas County, Ohio, that Ruth R. Miller did purposely cause the death of who was under the age of 13 years of age upon the commission of offense, and born on 10/12/2020, concluding that on or about August 23rd, 2025, cause of death as a proximate result of the offender committing or attempting to commit the offense of felonious assault in violation of 29.3.19A1.
He had a lot of charges. He's naming them all.
Concluding that on or about August 23rd, 2025, that Ruth R. Miller, that was a parent or a child under the age of 18 years of age, she created a substantial risk to health or safety in this case of by violating duty of care, protection, and support.
We can get past this charges. Hang on just a second, guys. Because she had like, I think 20 different charges going on here. Let's see. Okay, here we go.
Also concluding that on or about August 23rd, 2025, that Ruth R. Miller unlawfully did knowingly cause or attempt to cause physical harm and their household member.
So much like the defense attorney, it wasn't a whodunit. There was no disputing what Miller did to her children. But the judge then talks about what it would mean for Miller to be legally insane. And he talked about 3 mental health evaluations that were done by 3 separate doctors in the time that Miller has been in custody in jail. And he talked about the findings. And this is what he said.
These are the findings that I have concluded, including that a mental status at the time the offense evaluation was conducted by Dr. Daniel Ringo, a forensic diagnostic center of District 9, was identified as a joint exhibit number 2 for the entered into evidence. In the report by Dr. Ringo, who is a board-certified forensic psychologist practicing with Forensic Diagnostic 9, who sets forth findings the report finds persuasive as to the York state of mind at the time of the offense. Dr. Ringo opined that the defendant at the time of the offense charged did have a severe mental disease, but did not have a severe mental defect. His opinion states that as a result of the severe mental disease, the defendant did not know the wrongfulness of the act charged. And that would apply to all of the acts that are charged, not just one, but all of them. The next evaluation that I reviewed was the evaluation of Dr. Susan Hatters Friedman of University Hospital's Cleveland Medical Center, Case Western Reserve University. He was identified as Joint Exhibit 3, and he was also in the evidence. Dr. Hatters Friedman opined the defendant at the time of the offense charge also had a severe mental disease and did not have a severe mental defect. In the report by Dr. Hatters Friedman, she sets forth again certain findings, which the report finds persuasive that the state of mind at the time of the offense. Her opinion states that as a result of this severe mental disease, the defendant did not know the wrongfulness of the acts charged. That would apply to all 7 counts of the indictment.
Now, the state of Ohio also did a mental health evaluation, and they found that Miller does have a severe mental disease that did not allow her to know what she was doing was wrong for all 7 counts in the indictment. The judge also said there were witnesses who said that Miller showed some signs of mental illness in the weeks leading up to that day that she killed her son in August. The judge believes that Miller truly believed that God was asking her to be swallowed by a fish. The judge then made his final decision. This is what he said.
Based upon these findings that I have made in this case, I am concluding that pursuant to Ohio Revised Code Section 2945-37, that the defendant, Ruth R. Miller, is not guilty by reason of insanity. I think that's the only conclusion that can be reached in this case based upon.
Did you hear that? Not guilty by reason of insanity. Now, if you remember, Lori, damn it, sorry guys. Letitia Stouts tried to say the same thing, right? She pled not guilty by reason. Of course, she did not get the kind of outcome that Miss Miller had, but you see how differently Miss Miller acted and her reactions were versus Lindsay Clancy, Lori Vallow, or even Letitia Stouch. So anyway, we'll let this finish up real fast.
After and concluding that you are not guilty by reason of insanity on all 7 counts, aggravated
7
murder,
counts.
Under 29 of 3.01C, murder under 2903.02B and D, felonious assault under 2903.11A1, endangering children, count 4, under 2919.22A and E, domestic violence, counts 5, 6, and 7, all misdemeanors of the first degree under 2919.25A will have the conclusion that the evidence supports the state that is not guilty by reason of insanity. Now that they
Then they're going to do a separate. They're going to do a separate hearing on what her punishment actually is. It was not stated in when they did her bench trial. So we'll move away from her and we will go back over to Lindsay Clancy. But I just wanted to show a little bit, when we're talking about family annihilation and family annihilators, the differences. I mean, it's so stunning about these women and how they can do this. Well, that one was in the name of religion, but what about the others? Anyway, so here we go. We're going to get back to Lindsay Clancy, and this is her hearing for 3 days ago. Let's keep going.
To be able to comply and conform to the requirements of the law. That's black letter law definition of the lack of criminal responsibility, which is a separate issue and has been recognized as such by the SJC, as I say, in Cromwell versus Stewart. I believe in some other cases in dicta, they recognize the fact, which we all, I think, recognize, that there are two issues: defendant's mental state and whether or not the defendant committed the offense. Now, this is where it gets into what I think is very interesting as it relates to the Massachusetts Constitution as opposed to the federal Constitution. Now, the Massachusetts Constitution, as your Honor is well aware, predates the United States Constitution. And in fact, the framers of the United States Constitution drew upon language, for example, on the issue of the Fifth Amendment. They drew upon language that our framers of the state constitution said that no person shall be compelled to give evidence against themselves. U.S. Constitution talks about no person shall be compelled to give testimony against themselves. So there's a difference there, as your Honor is well aware. Excuse me. So when you consider the Massachusetts Constitution and the fact that that has predicted.
I'm gonna stop watching that for a minute. Let's talk about family annihilators, because really the show is about Lindsay Clancy as a family annihilator and family annihilators in general. So here's another thing about family annihilation. Between 1900 and 1999, there were 909 mass murder incidents in the U.S. And the definition of mass murder, I mean, as 4 victims within a 24-hour period. That's what makes a person a serial killer as well, okay? Of those, more than half occurred within an immediate family, so family annihilations. Although familicide cases are relatively rare, they are the most common form of mass killings. However, statistical data often are difficult to establish due to reporting discrepancies. Familicide differs from the other forms of mass murder in that the murderer kills family members or loved ones rather than strangers. This has a different psychodynamic and psychiatric significances, but the distinction is not always made. Okay? A study of 30 cases in Ohio found that most of the killings were motivated by a parent's desire to stop their children from suffering, which is that mental illness. Think about it. According to an ABC News contributor and former FBI agent, Brad Garrett, people responsible for killing their families tend to be males in their 30s. Many of these crimes occur in August before school starts, which may delay detection and investigation. Now that's strange that they've narrowed it down to a month of the year. In Australia, a study was done of 7 cases of familicide followed by suicide, in which the marital separation followed by custody and access disputes were identified as the issue. Some common factors such as marital discord, unhappiness, domestic violence, sexual abuse, threats of harm to self or others were found in varying degrees. It was not clear what could be done in terms of prevention. Yes, what are the red flags and how can you prevent, family annihilation? That's the hard question right here. So in the Birmingham City University, researcher Elizabeth Yardley, David Wilson, and Adam Lyons, they just co-authored the taxonomy of the male British family annihilators. This was from 1980 to 2013. They examined British familicides in the period. Newspaper articles were used as a reference. The study concluded that most of the perpetrators were male. Men who murder their entire families usually do so because they believe their spouse performed a wrongdoing and that the spouse needs to be punished. They feel that the family members caused a disappointment, or they feel that their own financial failings ruined the point of having a family. And because they wish to save their family from some perceived threat. far fewer women commit familicide, and those who do usually have a different reason, including perceived or imagined loss of custody of children. Male family annihilators are typically driven by loss of control, including financial crisis, separation, or divorce, and may demonstrate evidence for domestic violence, while for women perpetrators, battery, abuse, or mental illness is more common than the act itself, more likely premeditated, and more likely to include victims under the age of 1 year old. The literature review done in 2018 noted that the contextual and offense characteristics of familicide among the 63 articles reviewed, 74 to 85% noted that the relationship problems or separation. This article also found evidence of financial problems, intoxication, and the use of firearms. This literature review unveiled that 71% of those offenses were motivated in regard to conflict between the two parents, and 29% associated to the perpetrator's situation in life. Lastly, this article reported 2 studies, one of which found that many of the motives involved feelings of abandonment, psychosis, and narcissistic rage. The other study found that 60% of the perpetrators were suicidal and 40% were homicidal. It's kind of an interesting thing, isn't it? So, Yardley, Wilson, and Lyons divide familicides into 4 different groups. And we talked about these different groups and the study when we first started our show. And it was anomic, disappointment, self-righteousness, and paranoid. In this typology of the anomic killer sees his family purely as a status symbol. When his economic status collapses, he sees them as surplus to requirements. The disappointed killer seeks to punish the family for not living up to his idea of family life. The self-righteous killer destroys the family to exact revenge upon the mother and act with the blames and blames on her, right? Finally, the paranoid killer kills their family in what they imagine to be an attempt to protect them from something even worse. So, Miss Miller over here, family annihilation, clearly, by the evidence given to the judge, was mentally ill and was found to be guilty by reason of insanity. So, the others that we've talked about today were not. Lindsay Clancy, we don't know what she's going to be considered. So let's talk about some notable familicides that have happened. These are in the history of people who are family annihilators. George Forster. December 5th of 1802 in London, England, Forster allegedly killed his wife and child by drowning them in the Paddington Canal. Now, I cannot say this person's name. It is, I'm going to pronounce it wrongly, I'm sure. Juhani Atamapoika, okay, October 18th of 1849 in Finland. He killed his mother, stepfather, and their 2 children, who were his siblings. Leah Charlton, May 18th of 1890, in Liverpool, England. Charlton, who had an unidentified mental illness, slit her 3 children's throats before attempting suicide, which kind of sounds like Lindsay Clancy, but she did not slit their throats. So, Frederick Bailey Deemings, July 26th of 1891, in Rainhill, Lancashire, England. She killed his wife and 4 children and fled to Australia. Marty Bergman, January 19th of 1900, in Brookfield, Massachusetts. Bergen killed his wife and 2 children with an axe and then slit his own throat. James Reard Baxter, April 1908. In New Zealand, Baxter killed his wife and 5 children and then himself. Mateo Banks, in April 18th of 1922. This happened in Argentina. Banks shot dead 3 siblings, 2 nieces, 1 sister-in-law, and 2 family employees. Charles Lawson, December 25th, 1929, in North Carolina. Lawson killed 6 children and his wife with a 12-gauge shotgun, bludgeoned the bodies to make sure they were dead, and then walked into the woods and shot himself. Magda Goebbels and her husband Joseph, May 1st, 1945. The Goebbels fatally poisoned their 6 children before committing suicide together. John Eder Clark, June 3rd of 1956. This is a politician at the time, killed with a rifle 5 members of his family, his wife, son, and 3 daughters. Among the dead were also visitors and a hired farm worker. So he took everybody out. Lowell Lee Andrews, November 28th of 1958. This happened in Kansas. Andrews shot his parents and his sister. Then there were the Troy Axe murders. September the 28th of 1964, William G. Gravelin, a fireman who had recently exited a state hospital after slashing a cousin's wife, murdered his wife, daughter, and 5 stepchildren with an axe. They tend to like using slashing items, knives, axes, these kind of things. Alice Crimmins, July 14th of 1965. This is from New York City. Crimmins allegedly murdered her 2 children with help from a persons unknown. Charles Whitman, August 1st, 1966. This was right here in Austin, Texas. Whitman killed his wife and mother before committing the University of Texas. Okay, this is a very famous case. Whitman is responsible for the tower shootings at UT Austin, where he killed 15 additional people, wounding 31 others. He had also killed his wife, his mother, before he went to the tower and started shooting at the students at University of Texas. Very, very sad day for Texas. Jeffrey McDonald, February the 7th, 1970. This is out of North Carolina. McDonald killed his pregnant wife and 2 preschool-aged daughters. John Liss, November 9th, 1971, in New Jersey. Liss killed his wife, mother, and 3 children. Then, of course, there's also, we all know about the Amityville Horror, Ronald DeFeo Jr., for November the 13th, 1974, in Amityville. DeFeo killed his father, mother, 2 brothers, and 2 sisters. Then there's James Rupert, March 30th of 1975, in Ohio. Rupert killed 11 family members. Simon Peter Nelson, in 1978, out of Illinois. Nelson killed his 6 children, the family dog, and then assaulted his wife before being arrested. Of course, then we have Diane Downs, another very famous case. May 19th, 1983, in Oregon. Downs shot her 3 children, killing 1 and leaving the other 2 permanently disabled, and attempted to blame it on the carjacker. The White House farm murders. August the 7th of 1985. Oh, this happened in England. His name was Jeremy Bamber. Shot his parents, his foster sister, and her 2 children. Francis Newton, April the 7th of 1987, in Texas. This is over in Mount Houston, Texas. Newton shot her husband and her 2 children. Ronald Gene Simmons, not Gene Simmons from the famous band. This happened in Arkansas, and this was December the 22nd through the 26th. This guy took 4 days in 1987 to take out 14 family members ranging from 20 months old to 46 years old. 4 days. David Braum, February the 18th of 1988, over in Minnesota. Braum, he was 16 years old, murdered his parents, Bernard and Paulette, his younger brother, Richard, and his sister, Diane, with an axe inside the family home. Another slasher. Now, this one happened in California. It's Jose Esteban Barce, July 25th, 1988, in California. Barce killed his wife, a daughter, Judith, before committing suicide 2 days later. And I'm sure he sat in the house with those people all the while before he took his own life. The murder of the This is the DeLise children. August the 3rd, 1999, in Michigan, Lawrence DeLise drove the family station wagon into the Detroit River, drowning his 4 children. He and his wife both survived. Then we have the Menendez brothers. August the 20th. The 2 brothers murdered their parents, Jose and Mary. Then we have the Pukaki Massacre, and this was in Auckland. Brian Schlaffer, who had suffered from a mild depression, murdered 6 members of his family on their farm before killing himself. And then there's Ricardo Barada. November the 15th in Argentina. Barada killed his wife Gladys McDonald, who was 57, his mother-in-law Alina, who was 86, and 2 daughters, Cecil and Adrian. John Claude Romand. This was January the 9th through the 10th in 1993. This happened in France. Romand killed his wife, 2 children, his parents, and the family dog, attempted to kill his ex-mistress. See, they just get on the spree there, and they just take them all out. There's the Zarinsky family murders, June 9th, 1994, in Okaloosa County, Florida. Edward J. Zarinsky, a United States Air Force surgeon, murdered his South Korean wife and their 2 children by fatally striking them with a crowbar and a machete. Zarinsky was sentenced to death for the triple murders. Then there's the Bain family murders that happened in June 20th of 1994 in New Zealand. 5 members of that family were shot to death either by Robin Bain, the father of the family, or the eldest son, David, who was the sole surviving member of the family. David was convicted on 5 counts of murder in 1995, but was acquitted in a retrial in 2009. Susan Smith. We all know who Susan Smith is. October the 25th, 1994, in Union, South Carolina, Smith drowned her 2 sons in the lake and blamed it on an imaginary black hijacker or carjacker, either one. The Freeman family murders. Now, this happened in Lehigh County, Pennsylvania, February the 26th of 1995. 2 brothers and their cousins murdered the brother's parents and the younger brother. Then we have our famous Darlie Routier. On June 6, 1996, in Rolette, Texas, Routier allegedly stabbed 2 of her sons to death before staging the scene as a home invasion. Then we have another Arkansas woman, Christina Marie Riggs, on November the 4th of 1997. She smothered both of her children before attempting suicide herself. Kip Kinkle, May 20th in Springfield, Oregon. Kinkle killed his parents before committing a school shooting at Thurston High School the following day, leaving an additional 2 dead and 25 wounded. When I hear about the school shootings, it upsets me so bad because in most of those cases, they got the gun from the parents' home. The gun was not locked up, and that was 100% the parents' fault. Vladimir Pohico, this is another one, Pohico. Over in California, Pohico bludgeoned and stabbed his wife and son to death before committing his suicide. He slit his own throat. Now, that's very hard to do. Okay? Seth, and then there's another one, Seth Pervicki, murdered his family, his mother, his father, his brother, his brother's girlfriend, and grandfather on Thanksgiving weekend on November the 29th of 1998, fearing eviction from his parents' home. He didn't want to be homeless. In 1999, there's the Atlanta day trading firm shootings. On July the 27th of 1999, in Stockbridge, Georgia, Mark Orrin Barton bludgeoned his wife, son, and daughter to death before going on a shooting rampage at the day trading place before killing himself. There's Philip Austin. July the 10th in 2000, Austin murdered his wife, 2 children, and the family's 2 dogs. Then we have Lundy murders. August 29th of 2000, in Hamilton, North New Zealand, Mark Lundy murdered his wife and daughter. Robert William Fisher. This happened in Scottsdale, Arizona. Fisher had been charged with 3 counts of first-degree murder of his wife and 2 children and 1 count of arson. He is currently a fugitive from justice. This guy is still on the run. How does that happen? Think about that. We have Dipendra Burkam Shah. This was over in Nepal. He killed 3... Mr. Dipendra allegedly killed the royal family of Nepal at a family diner and died from a self-inflicted gunshot to the head. Then we have famous Andrea Yates, the other mother who clearly tried to claim she was in a psychosis. On June 20th, in Clear Lake City, Texas, Yates killed her 5 children aged between 6 months and 7 years. We have Seth Gonzalez from Sydney, South Wales. Gonzalez killed his parents and sister with a knife and a baseball bat before attempting to frame it as an anti-Filipino hate crime. They always try to blame somebody else, right? Then there's the Bluestone family members. August 28th of 2001 in England, Carl Bluestone killed his wife and 2 of the 4 children before committing suicide. Then we have Kristen Longo. December the 18th in 2001 in Lincoln County, Oregon, Longo killed his wife and 3 children. Then we have the Vincent brothers over in Bakers, California. The brothers shot his wife, their 3 children, and his mother-in-law. Then we have Marcus Wesson, March the 12th, 2004, over in Fresno, California. Wesson killed 9 of his children that he fathered through his legal wife and his polygamous wife, which also his daughters and nieces. So he took out the whole family as well. Christopher Porco, November the 19th, in New York. Porco murdered his father, Peter, and severely disfigured his mother, Joanne, in an attempt to cover up his financial problems and exploitation of his parents. And so that is the murder of Peter Porco. Dina Schlossler dismembered her baby, Margaret, on November the 22nd, 2004, and was later acquitted by reason of insanity. So that's one that won an insanity. And then we have Neil Entwistle. This happened in Massachusetts. Entwistle killed his wife and infant daughter. We have, the list goes on. There's so many of them, guys. I could be reading all day. But let me tell you somebody who's not on this list that should be on this list as far as a family annihilation. And that is, y'all are going to say, what? Yeah. As far as I'm concerned, Miss Gypsy Rose Blanchard is a family annihilator. She killed her mother, the only parent that she lived with or had ever lived with. That was the only family that she really had any association with. But okay, so I'm gonna call her a family annihilator as well. So there is just so many of them, and the reasons are all over the place as to why these people do these things. Now, as far as Lindsay Clancy is concerned, I need to make a correction to something I said the other day because I was actually wrong, and I did not know I was wrong, and I will always correct. If I'm wrong, I'm going to tell you I'm wrong. And that was in her court hearing the other day. Her husband was not there. That was not her husband that was sitting over there in the blue shirt. I believe now that I've been told that that was actually one of the camera operators that was in the courtroom. The reason why I thought it was her husband was because the guy was crying the whole time. I was like, oh my God, he's crying. So let's continue watching the hearing from 3 days ago as we talk about Lindsay Clancy as a family annihilator.
Additionally, provided greater protection to a citizen than the United States Constitution. I'm suggesting that under the Massachusetts Constitution, coupled with the dichotomy between defendant's mental state and the commission of the crime, coupled with the government's obligation to prove beyond a reasonable doubt, and then coupled again with the defendant's constitutional right not to make any effort to present any evidence against himself or herself, that in fact, the court should be able, in the sound exercise of discretion, to determine that if you have a trial and the defendant is compelled to go to trial not only on the obligations that the government has as to proving guilt of the offense, whether it's a bank robbery, whether or not it's an alleged rape, whether or not it's a homicide, the government has to prove that the offense occurred. However, you've also got that next layer, which would be whether or not the defendant has, as the SJC says, mental responsibility. So if you consider it in that fashion, we do not have to present and should not have to present evidence in the, let's say, guilt phase of the case. So if you have the guilt phase of the case, and then you have the criminal responsibility phase of the case, if Your Honor denies this motion, we try the case the way they're all tried. Government presents their case, presents their evidence, determining whether or not jury's going to find this defendant guilty. Then I have an obligation to present evidence that would be consistent with the lack of criminal responsibility, and evidence of that lack of criminal responsibility will obviously implicate criminal liability. So that's the problem that we have in this type of structure that we deal with. And that's why I think that it's very, very appropriate to have the bifurcated trial as requested in the motion. So looking at the other cases that I've looked at, I think clearly where you have the U.S. Constitution, they have the, let's say, the minimal protection. The Massachusetts Constitution provides a greater protection. And a defendant should not be placed in a position of presenting evidence in the course of a trial because, for example, in the grand jury, you have wonderful...
Okay, for fair use, we have to stop every once in a while and have some commentary. But let me tell you one thing about this, which is, it's just the facts out here about family annihilators. Most of the male family annihilators are white men. The majority of them, of the perpetrators, is white. They're white men. Isn't that wild? I found that to be odd. That is, and color should never be any part of this, but most of them are white males. Then you have the rarity of the females. However, to me, it looks like if I can name 4 female family annihilators that have happened in the past, I don't know, 4 years, 5 years, then I believe that they need to relook at the situation, because I don't believe that there's that I believe it's about equal as far as men versus women and gender facts of who's family annihilators. Okay, we'll keep going. Thank you, guys. Again, thank you.
First responders.
Enjoy watching.
And what these people went through is just horrific. But they had one witness after another, after another, after another, after another. Firefighter, 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 EMT, police, all describing the same thing that they saw when they went into that house. And that's going to be a replay on the trial itself. So the government should be in a position of presenting their evidence on criminal activity without trampling on the defendant's right not to be presenting evidence, quote unquote, against herself in that phase of the trial. And if we were to have the bifurcation, that would solve that problem.
Let me ask you, because I did have an opportunity. I read through kind of the same cases everybody's read through, you know, Siegfried, Blanchett, all these other cases.
Right.
And I would agree, phrase dearth of law does seem to apply. How would you suggest procedurally doing this?
That they proceed with their evidence as it relates to the circumstances involving the death of the victims in this case, and the circumstances surrounding what the police observed, circumstances surrounding any, as the government argues on murder cases, whether or not a person had knowledge, whether or not a person took pleasure in, for example, the suffering of the victim is one of the Hunter and Canine factors that we've talked about over the years with first-degree murders. That all goes on the issue of criminal liability. Doesn't really touch upon criminal responsibility. So in the event that, in the first phase of the trial, on the responsibility coming after, I suggest to the court, a jury could return a verdict. They could say, okay, we've determined that the government has sustained its burden of proof beyond a reasonable doubt. We find the defendant guilty based on the facts that have been presented, and then it moves into the issue, which really is the main issue in this case, of lack of criminal responsibility.
So I guess what I'm struggling with is the jury would come back with a verdict
based on the facts.
Based on the fact, guilty or not guilty. We'll assume it's guilty.
Correct.
And then would you ask them to undo that?
No. Then you get into the second phase of the case, which deals with criminal responsibility, which is got to be a major consideration. And it should be a major consideration, which it would be if it's bifurcated. And if you have the initial phase is resolved by way of the factual evidence that the government has, telephone call made, 911 call made, witnesses appear, witnesses observe, witnesses saw, pathologist, results of the pathology examination, all of that goes in the first phase of the case. Then after that is resolved, we get into the issue of lack or presence of criminal responsibility. And then we get into the issue of whether or not defendant was suffering from a disease or a defect, as a result of which she was unable to appreciate or conform.
All right. So, all right, Kamal?
Okay, hang on, guys, because next thing I want to talk to you guys about is some other information about family annihilators. I mean, hang on a second. 83% of family annihilators are male, and most of them between the ages of 20 and 30. These are just some facts about this. These killings often occur on the weekends, especially Sundays. August is the most common month. There is a link between domestic violence and family annihilation. Many cases involve prior threats, coercive control, or escalating abuse. Access to firearms significantly increases the lethality of it. There are always triggering events to these situations: financial collapse, exposures of fraud or criminal behavior, divorce or custody disputes, or protective orders or separation. Now, let's talk about the warning signs, okay? So we're going to highlight warning signs if there are any. And in some cases, there are not any. So hang on just a second. We're going to go back to this hearing as soon as we talk about this for a second. So here are the warning signs, especially in the male family annihilator, okay? These are just some red flags that people should notice, but for some reason they don't, okay? These are the patterns, not predictions. They're just red flags that often appear together in cases of familicide. Number one, there's the escalating control over the family, increasing surveillance of the partner's movements, monitoring phones, finances, and friendships, our sudden rules or restrictions. If I can't have them, no one will. I mean, it's that type of statement. Then there's the threats of self-harm or harm to the family. You regret leaving me. I can't live without them. We'd all be better off gone. These are threats of suicide in abusive men that correlate with threats to killing the entire family. Here's the major, and this is number 3, which is major identity collapse. So often it's tied to job loss, bankruptcy, legal troubles, public humiliation, exposure of fraud or infidelity. Okay? So, and why it matters is for the anomic type of annihilators, there definitely is fused with status. You know, when that collapses, they see their family as doomed, just doomed with them. They're just all doomed. Then there's the sudden isolation of the family. Now, pulling your kids out of activities, cutting off extended family, moving abruptly, we need to stick together kind of rhetoric. This matters because isolation increases control and reduces outside intervention. The other part of this is, and this is a very strong predictor, so think about this, a history of coercive control or domestic violence. This is one of the strongest predictors of family annihilators. And this could be man or woman, either one. Verbal degradation, financial control, stalking behaviors, physical intimidation, and destroying of property. Even without physical violence, coercive control is a major red flag. Then let's talk about the next one. Extreme perfectionism or rigid family expectations, especially in disappointed types. This is the disappointed type family annihilator. All right. Children must meet unrealistic standards. Obsession with image, reputation, or family honor. Shame with the family doesn't meet the expectations. Here's the next one. Paranoid or delusional thinking. This is important. This is why it matters. Belief that the world is danger. Conspiracy-driven fears. I'm the only one who can protect them. Sudden dramatic worldview changes. Would this be part of Lori Vallow's family annihilation? Was she a paranoid, delusional thinking, all in the name of religion? Why it matters? Paranoid annihilators often frame the murders as a protection. Okay? We saw that with Miss Miller over there. She's a family annihilator, and she protection. She gave him back to the Lord. Statements about the family being better off dead. This is a major red flag as well. Listen to what people say to you. They won't survive without me. I'm saving them from suffering. I can't let them go through what's coming. These statements often appear within weeks or months before this crime happens. Listen to people. It's important. Most cases have precipitating crisis, and this is a triggering event. Divorce filings, custody disputes, protective orders, affairs discovered, or this financial collapse. These are key patterns. The father feels he's losing control, status, or identity. Here's another, this is very important too, and this is why it matters. This can indicate the decision has already been made. Not they're thinking about it, but they've already made the decision. And that is the sudden calm after turmoil. Okay? This is one of those misunderstood signs. After weeks of rage, he becomes calm, accepting, and unusually affectionate. Begins giving away possessions. Makes cryptic statements about the future. Be weary. Be listening. If you feel you're in danger, contact somebody. Go get help. Don't wait until he's already or they have already made the decision and are taking the family out. what this turned into is a narration ready. It's just ready. It's just we're just talking about a checklist. We're just talking about things that can happen. We're just talking about red flags that people don't notice, but maybe they should. All right, let's go back to Lindsay Clancy and her hearing from 3 days ago.
Thank you, Your Honor. The Commonwealth presented 3 basic reasons why we're opposed to this motion. The first, obviously, is that the defendant does not have a constitutional right to a bifurcated trial. And that's not just from the Siegfried case in 1988. It was citing Bumpus from 1972, but it was also upheld in cases in the 80s as well as the 90s, as most recently in a case I found in 1996. So this is something that's been law in Massachusetts, that you're not entitled constitutionally to a bifurcated trial. Defense counsel brought up the Fifth Amendment issue and how that's different in the Massachusetts Constitution, but the SJC has already made it clear that when defense counsel and defendant choose to have the defendant interviewed by a psychiatrist and raise these issues and interviewed about the event, that they're waiving their Fifth Amendment privilege. So that doesn't come into play any longer once that's done. And that's been done here, and the intent here, as in Blaisdell, is to present that to a jury. The second issue is that the 2 trials would be nearly identical. Defense counsel has stated that certain witnesses might not be called, such as EMTs who come in and see the bodies of these 3 little kids on the floor in the basement. But Commonwealth argues that would be admissible evidence in the criminal responsibility portion, because it does go to mens rea. It goes to what she did, how she did it, why she did it, what her thought process was during that, how she planned to do that, and how much time she needed to do that. So these would basically be 2 identical trials, just like Commonwealth versus Scott from 1990 states that the evidence of a lack of criminal responsibility was related to the mens rea component of the crime itself as well. So you'd be having duplicate trials for no reason if we were to proceed in a bifurcated manner. All of the case law that I have found has been in instances where the courts have repeatedly denied a bifurcated trial, and the appeals court and the SJC have repeatedly upheld those decisions. And in his motion, defense counsel did not cite any reason whatsoever to make this case different than any other cases.
Okay. Now, we're going to go back and talk about a bifurcated trial again. Just because, I understand why they're arguing this, and I don't think she's going to win this argument, but it is a legal proceeding that is split into 2 separate phases, each decided independently. So it is like 2 different trials. It's used when 2 different questions must be answered, and combining them could confuse or prejudice this jury. For criminal cases, the phases are usually, number 1, the guilt phase. The jury decides, did the defendant commit the act? Are they legally responsible for their conduct? Do the elements of the crime meet the statutes? Right? Mental illness can be mentioned only as it relates to the intent, depending on the jurisdiction. And then there's the second part, which is what bifurcated means 2 separate, right? Phase 2 is the mental state or the insanity phase. If the defendant is found guilty in phase 1, the trial moves to phase 2. Here the jury decides, was the defendant criminally responsible at the time of the offense? Did a mental disease or defect prevent them from understanding the wrongfulness of their actions? And should they be found not guilty by reason of insanity? So you have a choice. You can plead guilty by reason of insanity, or you can have this other type of trial where you can be found not guilty by reason of insanity. Then there's this phase will allow psychiatric testimony, mental health records, expert evaluations, and evidence that would have been too prejudicial in phase 1. So they don't hear about a lot of the in phase 1, they're not going to hear things that they are going to hear in phase 2, because if they heard it in phase 1, they would just be prejudiced against her, and she would not fare very well. So why do defense attorneys request this? A bifurcated trial protects the defendant from the jury hearing their mental health evidence too early, which could make them look dangerous, make the jury think they're guilty and crazy, blur the line between did they do it or were they responsible. It forces the jury to first decide their guilt based on facts, evidence, intent, and statutory elements. Then only if necessary the jury evaluates their insanity. Okay, So this is why the prosecutors often oppose it. Intent and mental state are intertwined. Splitting the trial can confuse the jurors. It gives the defense two chances to sway the jury. It prolongs the case and increases the cost. This is why bifurcated trials can be common. They're typically used in a case that's involving insanity defenses, diminished capacities, extreme emotional disturbance, capital sentencing, guilt phase, penalty phase, juveniles transfer hearings, or complex forensic psychiatric issues. And, a bifurcated trial just forces that jury to answer those questions. And were they legally responsible for their actions, right? So that is why they're discussing this, and this is why they're having the argument. And I agree with the fact that, yeah, it gives the defense a chance, two chances, where in a normal trial you have one chance to persuade a jury. So here we go.
That have been heard in this county or elsewhere in the state, and cited no case law to support this request. So I'd ask that you deny the motion for those reasons.
All right. Anything further?
Very well.
All right. I'm going to take this under advisement, which is I want to go back. I read through all those cases. I want to go back and read through, considering the arguments of counsel. So I'm going to take that matter under advisement, but I'll get that decision out as soon as I can, because depending on what the decision is, might weigh in on the trial schedule and things like that. So I'll get that out as soon as I can. Is there anything else?
Your Honor, there had been defense counsel's motion to record the forensic interview. We've come to a stipulation regarding that. The parties have agreed that the interviews of the defendant would be recorded in the manner proposed in defense counsel's motion. However, the testing portions will not be recorded. Defense counsel is signed for his client today. We plan on providing defense counsel with another copy so that the client can sign it herself, but we could submit this as a placeholder to the court, or would you prefer we wait?
Well, my thought is it's probably good to have it in the file, then I can look at it and review it in regards to that. But and so, Mr. Reddington, if you can get that.
All right. If you remember the other day, we watched a hearing, and it was about the recording and the testing materials, etc. So they have came to an agreement on that. So that's one issue cleared in this trial. Now we're going to get off of here. I'm going to quit sharing the screen on this, because really that's the end of that. Is really just discussing. Okay, y'all cleared that up.
Ms. Clancy has an opportunity to sign it. That's fine, but I have that.
So
I accept your presentation that you've gone over that with her.
Yes.
So
Okay. Thank you.
now, so the date, if I remember, sometime in April, wasn't it? The evaluation.
Yes, Your Honor. April 10th, 11th, and 12th.
Mm-hmm. I'm looking forward to that.
And I know that we have dates at this point: June 18th, July 13th, and then trial date July 20th. Correct?
Yes.
Okay.
Does it make sense?
Everyone, put on your calendar at July the 20th. We will be live streaming. If it is live streamed, we're going to live stream this case on this channel, on all three of my channels, on Twitch, Kick, and YouTube. I wanted to follow this case from start to finish because I think this case is very, very important. It might, there's some things about this case that might change the way people see a psychosis, postpartum, and that kind of thing. So put it on your calendars. We're going to be watching it right here. You can watch it right here with me. We will not be on vacation that month, so it's going to work out perfect. Now, I'm going to get off of here. We're going to stop sharing the screen here, and we're going to talk about, should Lindsay Clancy get her bifurcated trial? Why it's important that they discuss it, and should she receive it or not receive it? So, why would it make sense for Lindsay Clancy's case? Well, the bifurcated trial usually just granted when two questions must be separated. And that is to confuse, because you don't want to prejudice her, but you also don't want to confuse this jury. You would want the jury to be able to make the correct decisions and hear everything properly and not get confused by this going on and that going on, right? Did the defendant commit the act? Well, we know she committed the act. That's really not even a question. But the question is, was she criminally responsible? Was she insane? Did she have a mental disease or defect? That is that's what the real argument is here. Now, when she's going to go and get her professional testing, and that will come out in the courts, okay? And after the testing is done, she might actually go ahead and decide to change her plea to guilty by not reason of insanity instead of not guilty. So the reason the judge might grant this in this case, because this case hinges on mental illness and medication-induced impairment. Clancy's defense centers on postpartum psychosis, medication interactions, diminished capacities, and criminal responsibilities. When the entire defense is about mental state, courts sometimes separate phases to avoid the jury hearing the psychiatric evidence too early. Then there's the risk of the jury prejudice. So, if jurors hear graphic details, mental health breakdowns, medication side effects, and psychiatric hospitalizations all at the same time, it's going to blur between the lines of did she do it or was she responsible? Bifurcation forces the jury to answer those questions separately. Okay. Then there's the Massachusetts. Massachusetts has precedent for bifurcation in insanity-based cases. She might win this based on knowing that Massachusetts has precedents for this, and this case is there. So, MA courts have allowed bifurcated trials in cases where mental illness is the primary issue, expert testimony is extensive, and it will be in this case, and the insanity phase requires evidence that would be prejudicial in the guilt phase. And in Clancy's case, fits that pattern, so don't be shocked if the judge actually grants it. Now, if he does not grant it, it's going to be, number one, the intent of mental states are intertwined. Intent and mental state, that's an intertwined. Prosecutors argue, one moment, I've got to let my little dog in. Hang on. Yeah, one moment, guys. Hang on just a second. I got to let my little dog in. She's hurt her little leg, and she's not going through the dog door very well. So let me just take a moment to let her in. Hang on, little baby girl. Mama's coming. Yeah. Come on. Come on, little baby girl. Trick, trick. These Frenchies, they're a bundle of love, a bundle of happiness, but boy, they are a bundle of vet bills. Let me just tell you that right now. All right, now we'll get back where we were. So, all right, baby, come on. So let's talk about Massachusetts and the reasons why the judge might not grant this. All right. Because we were talking about intent and mental state are basically intertwined. You cannot separate did she do it from why she did it. Her mental state is part of proving or disproving intent. If the judge agrees, they may keep it as a unified trial, not a separated trial. Bifurcation can prolong the trial. Because you have two phases, you have two sets of arguments, two sets of deliberations, and more expert testimony. Courts sometimes deny bifurcation to the streamline the proceedings because they don't want to sit through two separate trials. Now, the prosecution may argue the insanity evidence is not prejudicial. The judge believes the jury can handle all the evidence together with proper instructions. They may deny the split. So, should she get one? Well, there's an analytical answer to that. From the legal analysis standpoint, not an opinion, okay? A bifurcated trial is highly consistent with cases where the defense is insanity-based, psychiatric evidence is extensive, medication effects are central, and the jury could be confused by hearing everything at once. Clancy's case checks all those boxes, so don't be surprised. So there is a strong legal argument for bifurcation, not because it guarantees an outcome, but because it clearly separates the factual questions, did she commit the acts, from the psychiatric questions of, was she criminally responsible? Whether the judge grants it depends on how intertwined they believe the intent and the mental illness are, or whether they can think the jury can fairly evaluate both of these issues together. So that is what's going on with the bifurcation that they're asking for. And, that's what's going on with that part. But regardless, she's still a family annihilator, just like Chris Watts, just like so many others. I don't know, and I was going to look this up to see if I could find any studies on medication, family annihilators who it was driven by medication issues. And that's something I don't have the answer to yet, but I am going to do some digging to see if I can find anything on that, because I think it's important to understand all aspects. Okay? Hang on a minute. I got to answer my husband here. So that's just what I wanted to talk about today was family annihilation, mental illness, and how does this affect Lindsay Clancy and her trial. Again, remember, we're going to mark our calendars for July the 20th. This is when this trial is going to start. And we will be going live right here on our channel through the entire trial. Now, we also, July 20th, we'll be live. We're also going to look at some other cases. Okay. Hang on a second. That we're looking at as far as appeals, and I am going back to the Texas Supreme Court. We'll probably do Texas Supreme Court in the morning to talk about the ones that we were not able to see the other day because the court had a live streaming problem. So we'll probably get back on that. But mark your calendars. Mark your calendars. Mark those calendars for July the 20th, 2026 for the Lindsay Clancy case. We will be going live here on this channel. There you go. Anyway. That's about all I'm going to be able to talk about today. Mark those calendars. And what else did I want to talk about real quick? Let me think for just a second. My husband's trying to text me. Everything's going on. Okay, so that's going to be Lindsay Clancy is the week of July the 20th. Okay, put that right there. Put that there. Put this notice out. Right there we go. There we go. Okay. Mark those calendars, July the 20th. Okay, we will continue to keep up with the different parts of this case that are, they're having little hearings for this, that, and the other. Again, now let me also go ahead and remind you guys, yes, I made a mistake the other day. I claimed her husband was there. Her husband was not there. I have been corrected, and I'm correcting myself now because I do not want to ever mislead anybody when it comes to these cases, what's going on with these cases, and who was into the courtroom. Okay, so I'm going to let y'all go. You all have a wonderful afternoon. We'll see you tomorrow morning. Probably going to do a little bit of the Texas Supreme Court hearings that we missed. Have a wonderful afternoon. As always, thank you for stopping by. I always appreciate and always love seeing new people come in, talking with you guys. The dog's going to bark for just a second. Hang on, baby girl. See, they just want to go in and out all afternoon. Anyway, y'all go out there and take it easy. Be careful. Take care of yourselves and go hug your babies. Life is short, and it's even shorter your time with them. I'll tell you, the hardest job I've ever had is learning how to be an empty nester. And that's just a statement I'm going to leave y'all with today. Anyway, I'll see y'all tomorrow. Have a good evening. Bye, guys. Thanks again. Oh, and please hit that thumbs up and you're going in and out. I appreciate it. I always forget to ask. Today I've asked. All right. Bye, guys. A little word from our